Welcome everyone to the Making Connections webinar series. This webinar is presented by the Fall Prevention Community of Practice with technology support from the Seniors Health Knowledge Network. My name is Lindsay Toth and I'm a project coordinator at the Ontario Neurotrauma Foundation, which sponsors the COP. Marguerite Thomas also joins us on the line today. She is the coordinator of the Fall Prevention Community of Practice and will be assisting with the webinar technology. Before we begin, I'm going to give you a quick rundown on the Level 3 web meeting system. This webinar technology consists of two parts. The audio is provided through a telephone conference line, and the visuals are provided through a web platform. The phone number for the conference line and the link for the web platform were sent to you by email after you registered for the webinar with Level 3. If you have questions about the technology at any time during this presentation, please type them into the chat box located on the left-hand side of your screen. Alternatively, you can send me an email to lindsay@ons.org, and I will work with you to resolve technical issues as soon as possible. This webinar will contain an opportunity for discussion during a question and answer period at the end. If you have topic-related questions during the presentation, please type them into the chat box. During the Q&A, I will read those questions aloud to the presenter. If you would prefer to ask your question over the phone, we will prompt you and then you may unmute your line by dialing *7. When you're finished, we ask that you please dial *6 to remute your line to eliminate background noise. This webinar is being recorded. The recording and the slide deck will be distributed by email after the webinar. I would now like to introduce our speaker for today, Lawson Hennick. Lawson is a personal injury lawyer with Yermus Associates. Lawson, you may now unmute your line by dialing *7.
Hello?
We can hear you.
Thank you very much, Lindsay. It's an honor to be able to speak to everybody this morning or this afternoon. And I'm going to be talking about slip and falls with a particular emphasis on seniors. Now, it's important to note that seniors are not the only demographic affected by falls, but they are a significant demographic. So a lot of the emphasis will be given to the relationship between seniors and slip and falls in this presentation. Some of the goals for today are to basically, I want to explain why senior falls and senior fall prevention is important. We're going to go over some general legal information and principles and discuss some legal cases at the end which apply some of the concepts discussed. Also, I understand a large number of your audience members are in the healthcare facilities or are from healthcare facilities, and it's important to note that a lot of the things that we're going to talk about today deal with liability, focusing primarily on occupiers' liability, which is dealing with the safety of premises, not medical malpractice or anything of that nature. That's a separate area. So just to get started, one thing to keep in mind is in lawsuits, the best defense in lawsuits really comes from vigilant, proactive documentation and record keeping. Obviously, you can't control, if and when you're sued, but you can control the records you keep. So that's important to bear in mind. We'll start with some stats on senior falls because the significance of senior falls can't be overstated. We're in the age of the baby boomers, and some of the stats that I've been able to put forth to you today come from some research papers which are cited in my sources at the end. But almost a third of seniors fall each year, and the majority of these falls result in broken bones. So, 1/3 of fall-related hospitalizations are also associated with hip fractures. So it is a significant problem. And 20% of injury-related deaths in seniors are linked to slip and falls. So the we're talking about 1/5 of injuries related to senior deaths are attributed to falls. So it's crucial to be able to prevent that, and the law provides a framework for dealing with that. OHIP as well, and I think this data was taken from 2009 or 2010, spends about, at least in that year, about $962 million on fall care following senior falls. So that's something that also is usually claimed in lawsuits, but we can get to that later. This graph here talks about the cause of injury by age, and so what's important to note here is that falls account for the largest cause of injury to seniors, followed by overexertion. That's depicted here in this chart. This was a chart taken from Stats Canada, and it was based on 2009-2010 data. Why should we care? Well, as the population ages, fall prevention is going to continue to be a very real, important public health and legal issue. By 2036, it's estimated that about 10.5 million people will be within the senior demographic. So senior falls are likely going to continue to increase going forward. So it's important to be able to address these risk factors. Now, there's a number of risk factors associated with senior falls, and they can be broken down into a number of categories: biological, behavioral, environmental, and social and economic. From a biological risk factor perspective, we're dealing with things like muscle weakness, poor vision, which might predispose seniors to falls. Then there's behavioral risk factors. For example, not keeping a proper lookout or not paying attention. You got social and economic risk factors, which will usually address things like lack of access to transportation, for example, which may increase the likelihood of falling if they have to walk somewhere. But the key risk factor from a legal standpoint is environmental risk factors, because this really goes to the heart of most legal claims. It relates to inadequate maintenance, lack of handrails, problems associated with the physical environment. So as we delve more into the environmental risk factors, some things to bear in mind are that ice and snow accumulation, these are common environmental hazards that we see oftentimes in lawsuits. And then there's uneven surfaces like potholes, slippery surfaces, those kinds of issues. Now, this might be of particular importance to or relevance to healthcare facilities because they may service patients with particularly high risk factors, poor vision, mobility issues, and these kinds of problems might predispose their patients to a greater risk of falls. So perhaps the use of grab bars or matting, those kinds of things could go a long way in preventing those falls. And we'll get into the standard of care later on. Loose and missing handrails. That's another common hazard that we see. Poor lighting. It's particularly important to note that when you're dealing with a demographic that are predisposed to problems and they're entering your facility on a regular basis, and these are things that you want to ensure are in good working order. There's another pie chart here, just another chart from Stats Canada, which talks about activity associated with fall injury. The key takeaway from this chart is really that 45% of of fall injuries occur walking on surfaces other than ice or snow, and 16% of fall injuries involve walking on surfaces with ice or snow. So the key takeaway is really it's important to keep surfaces in good shape where people walk, whether that be surfaces, in your entranceway, just outside your facility, making sure the grounds are well maintained, salted, etc. So some potential areas of risk: parking lots, ramps, stairwells, entrances, bathrooms. Obviously, this is not a non-exhaustive list, but these are common areas where falls tend to happen. So when incidents happen, when people fall, as an occupier of property, you want to be proactive. And you want to be diligent in how the premises are maintained, because once injuries are suffered, it's not uncommon for lawsuits to be brought, and compensation may be recoverable against those at-fault parties. So on the topic of litigation, there's a number of goals associated with lawsuits. Okay, it really revolves around the compensation principle, which is to put somebody in the position they would have been in if the incident didn't happen. Okay, I mean, obviously you can't turn back the hand of time, but lawsuits help provide compensation for losses to, assist claimants to return to their pre-injury level of functioning as best as they can. There's also a deterrence factor associated with lawsuits, which is achieved through financial or reputational costs. Trials are a matter of public record, and the results can be very unpredictable. So you don't want to go through litigation if you don't have to, from the perspective of an occupier or property owner. So what's recoverable in a lawsuit? Compensation for pain and suffering are quite common. Loss of income and loss of competitive advantage. If there's an income loss, it can be proved. With a lot of seniors, many of them are retired or not working, so that may not be applicable. And of course, there's past and future medical and rehabilitation costs, which can certainly add up. And as I mentioned before, there's the subrogated OHIP claim that's recoverable as well. So the Government of Ontario, the Ministry of Health, will usually want to be reimbursed for whatever money they had to spend on treating the injured victim. So these would be recovered through the lawsuit as well. In terms of who might a victim recover compensation from, this is again another non-exhaustive list, but property owners, store owners, shopkeepers, municipalities, homeowners, restaurants, landlords, hospitals. These are a few examples of those who can be found liable. Now, occupiers' liability claims, they're common in venues with large numbers of patrons and customers, but they can also arise from claims at private residences. So they happen across the board. And most of these claims tend to be responded to and defended by insurance companies, which is why you have insurance on your premises. So oftentimes if you are sued, your insurance company would report it to your insurance company, and they would then take the steps to have the claim responded to. So that is very important to have. So important first steps after a slip and fall. What are some of the key things to do? It's key really to start building a paper trail. And I can't overemphasize the importance of documenting things, whether it be photos that can be used as evidence to support your case, obtaining witness contact information, or getting witness statements to support your case, whether you're on the side of the victim or from the perspective of the occupier. These are very important steps to take because they could play a key role later on in the lawsuit. Obviously, over time, people's memories fade. It's going to be more difficult to prove your case one way or the other. if you don't have this information. A common question I get often is, how much is my case worth? And there's no clear answer to that. But one key case in 1978 deals with a Supreme Court of Canada decision that imposed a damages cap of $100,000 for pain and suffering, which is currently worth about $358,000 today. So that's the amount of money that you will be awarded in Canada in the worst case scenario for a situation where you're rendered a quadriplegic, for example. Now there's also other areas of compensation, for example, economic loss, which is not captured under this cap, but as far as pain and suffering goes, that is the limit. The lawyer-health provider relationship is also very important. It's crucial for injured claimants to receive the needed treatment after an accident. One of the things that victims want to do after an accident is they need to get treatment, really for two reasons: to help themselves, but also if they're going to be able to prove a case later on. It's difficult to prove a case when you're not receiving treatment and you have large treatment gaps in your records. I often tell clients it's not so much about what the truth is, it's what you can prove. Somebody can be hurt, but if there's no paper trail backing up their complaints through a doctor or a physician or a healthcare provider, it's a lot more difficult to prove their case. And so, unlike with motor vehicle collisions, where you have statutory benefits available through one's own auto insurer, in slip and fall type cases, you don't have access to this. And so, unless you have collateral benefits or private insurance of your own, you might be on your own for covering physio fees or chiropractic fees. So partnerships between physio and treatment facilities and law firms through deferred payment arrangements might allow injury victims to get the help they need, while assisting them with their treatment and their legal case. So we're always happy to work with clinics who have patients in need of legal representation following an accident or say a motor vehicle collision or a slip and fall incident. So if you have patients that do need legal representation, we're certainly happy to do what we can to assist them. Now, some key concepts to talk about here, some key legal concepts are the concepts of the duty of care and the standard of care. We'll start with the duty of care. What is that? The duty of care is it's a legal relationship. It's created by law, and it imposes a duty to adhere to a reasonable standard of care. Common duties of care that exist at law are doctor-patient relationships, or drivers and other users of the road. Occupiers and persons entering the premises is another duty of care. They're codified in the law through court decisions or through statute. So, speaking of codifying the duty of care through statute, the Occupiers Liability Act, Section 3.1, sets out a duty of care. It's a legal duty imposing an affirmative duty on occupiers of property to ensure that their premises are reasonably safe for those entering on them. Okay, there's a duty on occupiers to take reasonable care to protect people entering on their premises from foreseeable harm. Okay, that's codified in the Act. Now I can see there's some questions here about grab bars. Lori Elliott Leach asked a question: if grab bars have been recommended by a professional assessment and a landlord refuses to allow them to be out, and the senior has a fall as a result, can the landlord be liable? You know what? That's a very good question. And I think why don't we wait until the end to address these questions, because I'm going to get to the standard of care later in the presentation. That'll probably be the best time to address everything, just so I can get through all the slides. So the duty of care, it was interpreted by the Supreme Court of Canada to be an affirmative duty. Okay, that there's a positive duty on an occupier to take reasonable care in the circumstances to make the premises reasonably safe for people entering on them. That was the Waldick case. Okay, this was a 1991 decision. So once that legal relationship is created, then the next hurdle that has to be addressed is the standard. Okay, was the standard met? Now, the requisite degree of care required is what that standard is. It's not expected to be perfect. The standards can vary in different circumstances. It's not a perfect standard, but what's reasonable in one case might not be reasonable in another case. So it's every case is going to be decided on the facts of its own case and circumstances. The industry standard, for example, is a good reference point. With the Ministry of Health, I know in the nursing home context, the Ministry of Health has a manual for standards and guidelines and procedures. So that can often be looked at for helping to assess what the proper standard of care is. So in a nutshell, occupiers' liability, it's liability imposed on those who own or possess or have responsibility or control over a premise, like a shopkeeper or a homeowner. And again, the Occupiers Liability Act, it governs liability claims in Ontario. So this act applies just to the Ontario jurisdiction. And it sets out where and to whom the law applies, and sets out the duty of care owed, as codified in Section 3, Sub 1, as I previously mentioned. So where does the Act apply? The Act applies on any premises, and the premises is broadly defined to include lands or structures, but it also includes water, ships, trailers, and portable structures designed or used for residence, business, or shelter, trains, railway cars, vehicles, and aircraft except while in operation. So it's a pretty broad list of what constitutes premises. Now, who does the Act apply to? Well, the Act applies to occupiers, and again, that's also broadly defined as somebody with physical possession of the premises or responsibility for and control over the condition of the premises or the activities carried on there, or control over the person's allowed to enter the premises. So that's a mouthful, but basically that's codified in the statute. And occupiers can include others besides simply the owner. Dangerous activities that are carried out on premises leading to harm to be subject to liability. So it's not just the physical condition of the premises, but it's the activities going on the premises as well that could lead to harm. Now, this is not in my slides, but I should mention that there is a section of the Occupiers Liability Act, Section 6 Sub 1, which deals with independent contractors, which allows for occupiers to escape liability if they can show that the independent contractor dropped the ball if certain criteria are met, namely that the occupier, they acted reasonably in entrusting the work to the contractor, and the occupier took steps to reasonably satisfy itself that the contractor was competent and that the work had been properly done. So an example of this might be a snow removal company who didn't salt and somebody got hurt. The occupier arguably may be able to invoke this section as against the independent contractor. But it's going to come down to the facts of the case. And again, the contract itself between the occupier and independent contractor may have to be examined just to see what areas were supposed to be covered, what duties and responsibilities was the contractor supposed to take on or not take on. That all has to be examined. Now, there's a question that was posed, which was, does reasonableness negatively impact those older adults who are at higher than average risk of falls? And that actually takes me to my next point here, because there's a concept called contributory negligence, okay, which is failure to take reasonable care for one's own safety. Oftentimes in slip and fall incidents, you're going to have some degree of contributory negligence because it will speak to the degree of fault that the claimant is to bear for their injury. Usually it will result in a discount in the damages by some percentage. Examples of this might include not keeping a proper lookout, being on your cell phone, or just not being in a situation to reasonably take care for your own safety. These might play into it. Okay, so it will reduce the quantum payable. Understanding the legal risk. Organizations, they can be held liable for the actions or the inactions of their volunteers or their employees. That's also known as vicarious liability, okay, for the actions of their staff. So it's important that the staff be trained and they be made aware of the company procedures and policies, because there's obviously financial and reputational costs associated with trials or litigation. And juries, if you do take a case to trial, can be very unpredictable. So it's important to safeguard against lawsuits. So the key legal considerations in safeguarding against lawsuits are really, number one, is there a reasonable policy and procedure in place for maintenance and inspection? And number two, were such procedures actually followed? So what's reasonable like I said before, it could come down to industry standard, and it'll be determined by the court. But you want to look at things like, were inspections done? How often were they done? Where were they done? Were the staff trained to do these? How does the training work? Is training is it on-the-job training? Is it reduced to writing and manuals? These are all things that the courts might look at in terms of policies and procedures. And then whether they were actually followed is another question. And that's going to require proof. So you want to be able to train staff to identify and remove hazards. But I can't emphasize enough, you got to document. Document. Because when an accident or an issue happens, there's going to be a requirement to prove that your reasonable system of maintenance and inspection was actually put into use. And that's going to be proved through documentation. Now, with slip and fall lawsuits, often generally speaking, you have 2 years to have a claim issued from the time of the incident. It's a 2-year limitation period. After that, you may be prevented from bringing a lawsuit, and there's policy reasons for that. I'm not going to get into too much detail about that, but essentially, the reason for that is it's not expected that an occupier or a potential defendant should have an indefinite dark cloud over their head for years. So be mindful of that limitation period, particularly if you're a victim of a slip and fall. Now we're going to get into some cases. I want to just briefly discuss 2 cases, and then we can get into some questions at the end. The first case is Soulier versus Casino Niagara. It's a 2014 case, and I'll briefly summarize it for you. So it was a slip and fall at a casino restaurant. It was a slip and fall that happened near the food station at the all-you-can-eat buffet. There was a greasy substance on the ground in the buffet area, and the plaintiff fell on the substance. So the issue here was, did the casino take reasonable care to ensure that the premises were reasonably safe for its customers? Well, in the decision, the court found that the standard of care had been met. It was a relatively small restaurant. There were 13 employees on duty. There was evidence that pointed to an otherwise clean floor. Each employee, as part of their job duties, was required to monitor the floor for food spills. Also, the claimant herself admitted that the floor was pretty clean. The evidence also showed that the fall happened so quickly after spillage. It was about 3 seconds after the floor, the substance was spilled. So, it's doubtful that, according to the court, it was doubtful that even the most vigilant inspection and cleaning policy couldn't prevent this fall. And that goes to the standard of care. It's not about having a perfect standard of care. It's about what's reasonable. No standard of perfection is required, especially in this particular case. It would be impractical to expect the restaurant to ensure that there was absolutely no spillage at all, because that's just not a practical reality of a busy restaurant. There was also a cleaning checklist that was produced by the supervisor of the restaurant. Although the court took issue with the checklist, the court said that it was vague and it was flawed. It's still important to note that there was still a checklist presented, okay, and that's an important thing to bear in mind, especially when we get into the following case. So the practical consideration really taken by the court was that the casino, it's a busy place, and food spills are going to occur regularly, and in this situation, they acted reasonably. The standard of care was met. The next case is a 2012 case. It's Dollarwall versus Premier Fitness Clubs, Inc. It's a 2012 decision. And just to summarize briefly, there was a gym floor there was water on a gym floor near a water fountain. The plaintiff's shoes got wet as a result of that, and he tried to dry his shoes. And shortly after, he went and began to use a vertical leg press in the gym. But his shoes were still wet, so one of his feet ended up slipping off the foot platform of this machine while he was using it. He could not hold the entire weight with one leg, and he quickly moved. There was a lock mechanism, that allowed him to try to put the lock mechanism in place with his hands, and his finger got crushed under the weight sled as the weight came down, because his one leg couldn't support keeping the weight up. The plaintiff, he admitted that he knew it could be a dangerous situation trying to operate a weight machine with wet shoes. And again, that would speak to contributory negligence. But the gym argued, they had a full-time cleaning staff in place. They had regular patrols made for spills specifically. There was a policy requiring uses of a warning sign to flag these types of spills and hazards. And the policy required use of that. There was also a reasonable maintenance system in place. Of course, the victim's lawyer argued that there were no logs kept to prove that such inspections actually had taken place. So the issue here is, did the gym breach the duty of care? You should probably say standard of care. But in either way, the court decided that the gym, in the end, failed to provide any evidence that the maintenance program was followed. And specifically, the court said, quote, "It may have been operational. There was just no evidence before me that it was operational." So there's no evidence that the maintenance system was operational. So, they had a system of maintenance inspection, but there's no evidence here that it was actually implemented. And that is the importance of why you need to document everything. Going back to the contributory negligence issue, the court found that the plaintiff was 50% responsible for his own injury. So instead of the gym being responsible for 100% of whatever the damages came to, they got a 50% discount because of the plaintiff's contributory negligence. So just, in conclusion, we're dealing with an aging population, and obviously the prevalence of falls will increase with the aging demographic. It's going to be very important for occupiers to take positive steps to prevent injuries from occurring, or they may face potential litigation. Having a reasonable system of maintenance inspection alone is not enough. It needs to actually be implemented. And so it's important to document these steps. Document when inspections are made, document what problems are noted, and what steps were done to rectify problems, to show there's an ongoing log of continuous activity to reduce risk. But documentation is not just important from the perspective of the occupier. It's also important to document from the perspective of the accident victim. You want to document your injury. The proof is going to be in the paper, so that might require going to the doctor, following up, getting treatment records generated and then put in place so that you can prove your case later on. So that concludes my my presentation, subject to any questions that haven't been addressed. And I thank you very much for your attention. And if there's any questions,
thank you very much, Lawson.
Don't be shy.
An excellent presentation, and I think something that we haven't had much exposure to through the Community of Practice webinar series prior to this. So we do have some questions. So I think we'll start off by going back to Lori's question about grab bars. So if grab bars have been recommended by a professional assessment and the landlord refuses to install them, and then the senior tenant has a fall, can the landlord be held liable?
It's possible. When you say an assessment, what kind of assessment are you referring to? Is this like a municipal assessment by the government, or
so it would probably be an assessment by an occupational therapist or another healthcare provider. And
is the assessment for the person to have a grab bar in their house or specifically?
Yes, so it would be specific to that older adult tenant.
Yeah. Well, I mean, if the recommendation is tailored to the older tenant, and it's based on something that needs to be modified in their own house, I mean, that's one thing. If there's some report that specifically says that they need access to a grab bar in a facility, and the facility is made aware of that, and they're not taking those steps, I mean, that might not be helpful to the facility. But I mean, generally speaking, if you're providing services to a particular demographic who have known predispositions to falls and tend to be more vulnerable, it may not be a bad idea to take those steps to ensure that they're protected. especially if they're coming to your facility on a regular basis, and you're aware of their problems ahead of time. It's just proactive.
Mm-hmm. So I think that feeds nicely into the next question about reasonableness and the fact that a lot of older adults are at a higher than average risk of falls. So how does that reasonableness relate to this population that's actually at a higher than average risk?
Well, I mean, the reasonableness will vary from situation to situation. So it depends on the context that we're talking about. I mean, if we're talking about, say, just to use an example of a parking lot where an elderly person falls and injures themselves versus the reasonableness of what's required of, say, a nursing home where somebody falls. There might be different standards in place for each situation because, with nursing homes, you know the type of people you're dealing with, and you know what their vulnerabilities are, and you're in the business of providing services to these people. Whereas, a parking lot, whether somebody falls or not, as a result of having a grab bar available or not having a grab bar available, or I guess a grab bar wouldn't make sense in a parking lot, but on private property and in a private bathroom, it's gonna come down to the facts of each case. There's no clear answer, but it's really going to be determined by the court. It's going to be determined by a jury. Juries are not predictable oftentimes, so that's how those situations are usually determined.
So would you say that older adults might be negatively impacted because just like the standard for public spaces that aren't specifically meant for, and designed for seniors, the standards are lower?
Well, I think it's fair to say that older adults are certainly more vulnerable to risk, and the risk factors are certainly going to make them more susceptible to falling and having a more difficult time at recovering because of their age and health. So yes, I think that they are at a disadvantage, but in terms of falls happening. But I think that the onus and burden really shifts to society as a whole, particularly occupiers, to take those reasonable steps to make sure that their premises are up to standards so that we can avoid these situations.
All right, that's a good comment. Another question from the chat box from Gail. What about PSWs, which are personal support workers, like home care workers, or they would sometimes work in a facility, going into a home with a dark entranceway? Would the owner or renter of the home be liable if something happened to the worker who was entering the home?
Yeah, I mean, regardless of your age or your demographic, if you're entering into a home that's dark and there's a fall that happens because of that, certainly there's a case that could be made, arguably, for negligence under the Occupiers Liability Act if the home isn't maintained in a reasonable manner.
So just a follow-up to that. So if the owner of the home was an older adult who had difficulty mobilizing and caring for themselves, which is the reason why they had someone coming in to help them, would their standard of care, the reasonable standard of care, be lower because they're not physically able to maintain the home as well?
That's a good question. I mean, if everybody had personal issues that were, the Occupier Liability Act sets out a duty that applies to occupiers, and occupiers, would include homeowners. So if, regardless of your health situation, if you have a property that's not in a good state of repair, or that has deficiencies that put other people at risk, then you could likely be liable. Saying that you have health issues that prevent you from maintaining your property may not persuade a court to exempt you from your obligations. So, if you're in that kind of situation, maybe you may want to think about moving somewhere where those duties are taken care of for you, or perhaps hiring a subcontractor to take care of any maintenance issues that might need to be addressed so that you don't have to do it yourself.
Interesting. Thank you. This is a comment from Gail again, but it's related to the question about grab bars and the assessment in the home. So please correct me if I'm wrong. My understanding from dealing with seniors in the community is that you need to have an assessment by an OT or physio, and that determines which equipment is needed, and it's the responsibility of the client or their family to provide that equipment. If bars are needed, it is once again the responsibility of the renter to provide the equipment with the approval of management of the building or the owner of the home to approve the bars being added to the rental space.
In all honesty, I'm not really entirely sure I understand the whole, just because I'm not regularly involved with occupiers or occupational assessment type procedures. I certainly can, it might require a little bit more looking into, but it's, again, without having the entire assessment in front of me, it's kind of hard to answer that question in the dark because I don't have all the facts.
Yeah, of course, no worries. So maybe, Lori, if your question hasn't really been fully answered, maybe you could contact Lawson after the webinar, and maybe you could follow up afterwards.
Sure.
Okay, another question from Ben. I often try to argue that a stair meets the code. A stair that meets the building code may not be a reasonable standard. Is that a hopeless effort?
That's a very good question. Certainly the defense lawyer for the premises will probably try to argue that if they're in compliance with the code, then it's good enough. We get similar types of situations with minimum maintenance standards in parking lot maintenance cases and that sort of thing. And the short answer is it depends. Again, it's going back to what facts you can present at trial, what a jury is going to think. I mean, there might be other factors in place that might convince a court otherwise. So that's just one of many factors, and it's one of those things that is so fact dependent that there's no clear-cut answer to that question.
All right, I think we're seeing a trend. All right, so this is a question from Marguerite. Lawson, do you have any advice for healthcare workers who may be called to speak in a court case?
Well, I think we often have healthcare workers that provide their input in cases, and they just have to be able to withstand questions from the other lawyer. They're going to have one key thing that healthcare workers need to have if they're going to be involved in the case is credibility. Obviously, it's going to help to have credibility and being able to back up your explanations. And oftentimes we use experts. We need experts. My medical opinion isn't worth the paper it's written on. I'm not a doctor. I'm not a healthcare specialist. So having those opinions and having them speak at trial and in court decisions is needed often. And as far as advice that I could give, I mean, it's not really my advice to give. It's their legal opinion that matters, or their medical opinion that matters, not mine. But just somebody who could back up their conclusions.
What type of questions, for what reason would a healthcare provider potentially become involved in a case?
Well, oftentimes there's legal questions that need to be answered. In the case of motor vehicle collisions, one of the key questions that, and that's sort of beyond the scope of slip and falls, but there's a test for, it's called the threshold test. In order for somebody to get compensated for pain and suffering, they have to have what's called a serious and permanent impairment of an important mental, physical, or psychological function. So that's a medical question that would require a report or an opinion oftentimes from a physiatrist or an orthopedic surgeon or somebody who's specialized in an area that can give that opinion. Also, with statutory accident benefits, there's a number of questions that are often asked of doctors and chiropractors and healthcare specialists to determine entitlement to benefits for clients. And again, those are the questions that would normally be posed to them. And if it goes to trial or arbitration, these are the things that are usually elaborated on.
Thank you. One more question. Can you give any examples of people being sued because of a slip or fall in a hospital or long-term care center? Off the top of my head, no. I mean, I believe there's case law out there that talks about that. I don't have any specific cases on point right now, but I'm willing to bet that there's an abundance of case law that deals with that. All right, so I'm going to give the opportunity now, just because we are drawing to a close of our webinar. If anyone has a last question, we'd invite you to ask it over the telephone, just so you're not typing and we don't know and we accidentally hang up when you have a question. So if you would like to ask one final question to our presenter today, please dial *7 on your telephone keypad, and that will unmute your phone line so you can speak. *7 if anyone's interested. Okay, and Marguerite Thomas, who's the coordinator of the Fall Prevention Community of Practice, she had a really nice comment that she wrote into the chat box. And Marguerite, I just invite you now to unmute your phone line if you would like to sort of say your conclusion and your main takeaway from this presentation. I thought it was really well put.
Hi, thank you so much for doing this presentation. I was involved in a court case in a hospital a number of years ago, and being an ordinary witness was really, it is quite stressful because you're quite right. The other lawyer will try to ask you 17 different ways of answering the same question. So the takeaway I'm getting from you today is document some more, know the policies in your workplace, and be sure that they're being followed.
Yeah, that sounds very much on par with my point today.
Thank you so much.
My pleasure.
Do you have any final words, Lawson?
I don't think so. I think it was summed up pretty accurately. You know, if I had 3 words of advice, I would say document, document, document.
All right, that's great advice. So I'd like to thank you very much, Lawson, for presenting for us today with that valuable information and on a topic that many of us are not as familiar with given our backgrounds in healthcare. So thank you. That was very enlightening. I'd also like to thank all of our participants for attending today and engaging in a great discussion. I'd ask that you please do not close this window just yet. Please wait until you've been redirected to the Level 3 lobby screen. Once you see that screen, it is safe to close the window, and a very brief evaluation survey will launch in your web browser. We'd really appreciate if you could take a few minutes to give us some feedback so that we can continue to provide high-quality webinars and improve in the future. A recording of this webinar will be posted on our YouTube channel, as well as circulated to all participants in the coming week or so. Please feel free to pass it along to any colleagues you think might be interested. For more information about the Fall Prevention Community of Practice, please check out Loop, our online communication platform at fallsloop.com. It's a great place for networking and discussing with your colleagues. So again, that's Loop, our online communication platform for fall prevention, and it's online at fallsloop.com. Thank you, everyone. Thanks again, Lawson, and have a wonderful day.
Thank you. You too.